In each of these matters, Mr. Cole is here today after failing to appear before this court on August 30th, 2023. In the first case, bond is currently set at $6,375. This is the 11th bench warrant. In the second case, bond is currently $2,305. This is the 24th bench warrant. And in the third case, bond is currently $1,261, and this is the 17th bench warrant. He reports that he is employed at Kane's Concrete. This is the same employer that he's provided before, and the enforcement officer has contacted the employer and has been advised that he does not work there. Last payment made on these accounts was in June of 2023. The court recommends that reasonable bonds be set in each of these matters, and they be scheduled for hearing on December 6th, 2023 at 8:45 a.m. before this court.
Mr. Cole, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 6th, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, because I just got injured, fell off a ladder, and this is the first time I ever used Kane's Concrete. The very first time I ever used Kane's Concrete as a service.
Okay. Regardless, they say you don't work there. So what's the issue?
I don't know how they figured that out this fast, but anyway, I just fell off a ladder about 24 foot. I had stitched over my eye. My wrist still ain't healed yet. And the last payment I did make, I hustled up on that money and paid that $40. That's how I did that. And as soon as I get done going through eye surgery, that's when I intend to make restitution. That's the only way I can make restitution.
Okay.
But I gotta have eye surgery.
Well, you have obviously you have a sizable arrearage in all these matters. And you've set a record. You have the record for the most bench warrants I've ever had in a case. So
Really?
it shows you've obviously been back in here a number of times and you haven't shown up. So what the court's going to do in both of these, the first, the 07 and the 98 or 89 case, I'm going to set your bond in the amount of $1,000 in each of those cases. And then in the remaining, the 98 case, I'm going to set it in $500. If you're able to post that, you'd be able to be released. Do you have any questions?
Nope.
Okay, thank you. You're free to go. Have a good day, sir.
Great.
You're too efficient, Mr. Chapman, and he found out so fast that he didn't work there.
DM. Mr. Glue is here today after failing to appear before referee Jordan on May 9th, 2022. Bond is currently set at $1,471. This is the first bench warrant. He reports no employment, and last payment made on this account was in April of 2023. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 6th, 2023 at 8:00 a.m. before this court.
Okay. Mr. Glue, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 6th, 2023 at 8:00 a.m. Are you able to post a bond, sir?
No, sir.
Oh, okay. Well, it is your first bench warrant, so the court is taking that into consideration. But you do have a sizable arrearage as well. What I'm going to do is set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're excused. Have a good day, sir.
Mr. Witt is here today after failing to appear before referee Delmont on September 16th, 2021. Bond is currently set at $890, and this is the first bench warrant. He reports no employment. The last payment made on this account was in November of 2023. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 6th, 2023 at 8:45 a.m. before this court.
Mr. Witt, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 6, 2023 23 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No.
Okay. Well, you do have a sizable arrearage in this particular matter, so the court's taking that into consideration, but you haven't paid, again, you've only been, this is your first bench warrant, so the court's also considering that. And you did make a payment earlier in the month, so I'm taking all of that into consideration. What I'm going to do is set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're excused. Have a good day.
9:09 a.m.
Thank you, Your Honor.
Good morning to everyone. The court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Ms. Boland on behalf of defendant. This matter is before the court on the defendant's motion for modification of parenting time and support. Ms. Boland.
Thank you. Good morning, Your Honor. Yes, defendant here is requesting increased parenting time due to change in circumstances. It's been almost 2 years since the party's parenting time schedule has been modified. And since then, there has been a change in circumstances, and that defendant has a different job with a schedule that does allow him to get the children to and from school, which is different from when the last order was entered. The defendant has completed counseling with the children, which has given him tools to improve his relationship with the children, as well as their co-parenting relationship, which both have improved. And the children have also expressed that they want to be with the defendant more, and defendant would like the same. Considering those change in circumstances, defendant is asking for increased parenting time to, right now he only has alternating weekends from Friday to Sunday and holidays, just as the parties agree. So he does not have the standard midweek visits, equal summers or holidays per the policy. And he would be asking for parenting time alternating Thursdays until Mondays, the midweek visit, holidays and summers per the policy. And at this point, I have spoke with Attorney Podolsky, and it sounds like both of our clients are willing to attend mediation with Attorney Brundage to see if we can resolve this issue pending a FOC evidentiary hearing.
Okay. Ms. Podolsky, is that an accurate recitation of what you've agreed to?
We have agreed to participate in a mediation with Attorney John Brundage. We don't, obviously, from our response, agree with all the statements made in the motion or the request to expand parenting time to the extent to which they are requesting. However, we do believe that a mediation with Attorney Brundage could be beneficial in this matter. As it relates to defendant's employment, he's not made my client aware of any job change in schedule, income, anything of that nature. So at a minimum, a review of child support would be necessary if his employment has in fact changed. But in the interim, we do agree to mediate with John Brundage.
Okay. Well, in this particular matter, in view of the I guess you say agreement, the court will send the matter to mediation with Mr. Brundage as per the agreement of the parties. The parties would in fact bear 1/2 the cost of that mediation. And what we'll do is I will not send the matter, not refer it to the front of the court referee in this matter until mediation is completed, because again, you very well could end up with a hearing date before mediation and have to adjourn that. So I'll leave it up to the two attorneys to inform us what happens as it relates to mediation, whether that's successful or not. And if it is not successful, then we will do a referral order at that particular time. Ms. Boland, I'd ask that you would prepare an order in this matter, referring it to mediation, and then stating as well what I have held in this particular matter, and that alerted the parties to pay 1/2 the cost of the mediation.
Will do, Your Honor. Thank you.
Okay, thank you. Anything else, Ms. Boland?
No, thank you.
Ms. Podolsky?
Nothing, thank you.
Okay. Thank you. The court will end this matter at 9:14 a.m. Court will You're free note to the go. appearance Have of a Ms. good day. Paisno on behalf of the plaintiff, Mr. Sebastian on behalf of defendant. This matter is before the court on the defendant's motion to set aside referee order. Mr. Sebastian.
Thank you very much, Your Honor, and good morning. Your Honor, the referee did a very good job with this, and it's really 100% accurate as to the referee's knowledge at the time of issuing the order. However, at the time, almost the day the order came down, the defendant lost his position at Stuart Sutherland because another operator was brought back for that position. He has since now has employment as of November 20th with Twisted Automotive in Comstock Park at the rate of $20 per hour for 40 hours per week. So the referee had imputed 30 hours per week at minimum wage from September 1st to October 30th, which was the date that my client had started working at Stuart Sutherland. But unfortunately, he was only there for a week, lost that position, and then it took until November 20th for him to get a new position at Twisted Automotive. So what we're asking the court to do is amend the recommendation or send it back to the referee to redo the recommendation so that the imputation at 30 hours per week would go from September 1st, 23 to November 20th, 23. And also then do the new income withholding order for the new employer, Twisted Automotive in Comstock Park.
Okay. Ms. Paisno, what's your response?
Your Honor, I hope that Mr. Garrett still has his job at Twisted Automotive since he was arrested again last night. And I'm not sure why. I do believe that $20 an hour at 40 hours a week and then producing a pay stub from November 20th of 2023 moving forward is appropriate. However, I do not believe that it's appropriate to amend the recommendation for the time period of September 1st to October 30th, moving on to November 19th, due to the fact that it's my understanding based on a subpoena that I received that the reason Mr. Garrett lost his job at Stuart Sutherland is because of voluntarily abandoned his job. It's my understanding he refused to do a drug and alcohol screen for the employer, so he left the job. So because it was a voluntary abandonment based on the subpoena response, I would ask that you deny that request of the motion.
Okay. Mr. Sebastian, what's your response?
So in the subpoena documents, it does say job rehire. The subpoena documents are a little confusing in terms of what happened there. My client advises me that an operator was brought back. And then because of that, there's kind of a long story about this drug test about they offered him some alternative position, but it was even less at $16 an hour. And then he had to go take a drug test to get the position. And there's some sort of long story about that. But the bottom line is he did lose that position, according to him, because a previous operator was hired back for that position.
Okay. Well, obviously there are some factual disputes, et cetera, but looking at what the referee did in imputing minimum wage at 30 hours, he did give substantial consideration to the defendant at that particular rate. And obviously, it's less than full time. Typically, I will tell you, if the court were to make an imputation, the court would impute $15 an hour at full time. So the referee was very considerate of the defendant in this particular matter. I just don't, based upon what I hear, I don't see whether the referee had made any factual or legal errors in this particular matter. So as a result, the court will deny the motion. However, as a result of the new employment taking place November 20th, the court would allow Ms. Paisno for you to recalculate the support as of the November 20th date and put in a new UCSO from that date forward. Ms. Paisno, if you would, you can, we'll do a deny. We have a referral order on that denying it. So we'll do the order, and then you just do the new UCSO, and you can submit under 7 day, Ms. Paisno.
I can do that, Your Honor.
Okay. Thank you all. Have a good day. We'll end this matter at 9:37 a.m. Your court will note the appearance of Mr. Kelly on behalf of the defendant. This matter is before the court on the defendant's motion to enforce order for contempt, make up parenting time, change of custody, and attorney fees. In this particular matter, the plaintiff has filed an answer. Have you reviewed that answer, Mr. Kelly?
Yes, Your Honor.
Okay. I think based upon the answer, the court would need to have an evidentiary hearing in this particular matter. What are your thoughts?
Your Honor, I would suspect that that would be appropriate under these circumstances if the court did not feel inclined at this time to even change custody on a temporary basis pending that hearing. However, we would like to at least get his makeup parenting time addressed because I'm sure the court's calendar is pretty busy and we're probably looking at a little ways out before we can get there. We'd also like to address the kids getting back into a brick and mortar school because they're falling behind. And I looked up that website for Always Ice Cream, Your Honor, and it's a learn and play platform for girls. It's not a state of Michigan curriculum for online schooling. It's run by a software company out of Silicon Valley, California.
Well, what we'll do in this matter is we'll set it for an evidentiary hearing. I'll tell you that after reviewing the motion, the court is not convinced that we've met the threshold of Barker for change in custody, but all of the other issues can be addressed at that evidentiary hearing.
Okay.
I would state the court, however, as it relates to the contempt, the court does speak through its written orders, as I'm sure Mr. Kelly has heard over and over. So the court is not going to enforce any parenting time issues until that order went into effect on 10/4/2023. So it'd be any time after the 10/4/23 date. If there's any missed parenting time, the court would address that at that particular hearing.
Your Honor, the parenting time schedule has the current order simply says follow the Calhoun County parenting time guidelines, but it doesn't specifically address the holidays. I read that to mean include the holidays, and we have those coming up. We're in a unique situation in that the kids are not in a brick and mortar school where we can follow the school calendar.
Well, what we do in that case, Mr. Kelly, is we follow the school calendar of where they reside. So if they reside, let's say in Battle Creek Public Schools, you'd follow the Battle Creek Public School calendar, or if it's Lakeview or Harper Creek, whatever.
Okay.
I don't know where they reside either. So, but we would follow that particular calendar.
Okay. That makes sense.
What I'll do is that the defendant would be entitled to holiday parenting time because again, that's a standard. And who had the children just at Thanksgiving?
Mom did.
Okay, then defendant would be able to have the children for Christmas Eve parenting time and then alternate thereafter.
Okay.
And Mr. Kelly, you can prepare an interim order as it relates to the parenting time, the holidays, and submit that under 7-day notice of entry.
Your Honor, would it be beneficial for the court for me to cut and paste the Calhoun County's holiday parenting time so everybody knows exactly what it is?
If you want to, that'd probably be a good idea.
Okay.
If we're going to have any disputes, want to make sure that we don't. And then just if you would put in a date when that is alternating weekend started, that way there's no dispute in the future as to what those weekends would be.
Okay.
Okay.
Fair enough.
That's what we'll do today, and we'll set this for a hearing, and we'll have you back and resolve all the issues at that time.
All right. Thank you, Your Honor.
Okay, thank you. Court will end this matter at 9:42 a.m. You're free to go. Court will note the appearance of Mr. Stupak in this matter. The matter is before the court on the defendant's motion to modify judgment of divorce as it relates to change in domicile. Mr. Stupak, you're accurate as to the statute. However, the court rule does require that the court still make an assessment for change in domicile purposes. But again, the case law in this matter is simply that provides that the court just has to examine and determine if in fact the party does have sole legal custody. If they do, then the court, that's the only thing the court needed to analyze to determine if that's the case. If that's the case, then the statute does kick in and your client would be able to change domicile at that point.
Very good. Does the court specifically want me to produce the judgment that sets forth?
No, that's part of the court file.
That's what I would assume.
Yep. All I need you to do, Mr. Stupak, is to prepare an order granting your motion and changing domicile to, I don't remember what.
I believe it's going to be the state of Missouri.
Okay. Change it to the state of Missouri, and then that should take care of things.
Very good. Thank you, Your Honor.
Thank you. Court will end this matter at 9:44 a.m. Free to go. Have a good day.
Thank you.
Good morning to both of you. Court will note that this matter is before the court on the plaintiff's motion to show cause. Ms. Parrish, you may proceed.
Yes, we recently went to court to the defendant asked that post-majority support be ended for our oldest son. It was written into our divorce decree, and so it was you had ordered for a friend of the court to do a review. So they ended up ending that. And without that funds, now I would like to have a review of spousal support that was ordered that Mr. Parrish hasn't paying, that is ordered in our divorce decree, and through the spousal support for $700 per year. And that has not been occurring. Also, it's ordered that in the previous order, medical, he pays 60% and I pay 40 of the uncovered uninsured. And there has been two larger bills. I've been paying the smaller ones, just doing it myself to avoid conflict. But two of the larger ones, I would like to have him pay his portion. And then the third thing is tax filing status. I have the children. Well, now I guess the oldest has aged out, but our youngest, I have about 300 nights, and I would like to have filing status.
What does the judgment provide as it relates to the tax deduction?
It says that we are going to rotate once the oldest ages out, but that was supposed to be with the post majority. So now that's why I'm asking for that to change so that I can file her.
Okay, well, let me tell you, the court does enforce the judgments and the orders of the court. So in this matter, if the judgment provides that the parties would alternate filing status, the court is not going to change that. The other issues, guess I'll ask Mr. Parrish. Mr. Parrish, she stated you're not paying the spousal support or contributing to the medical. What's your response?
I have not missed any of the child support payments. Of course.
She didn't say child support. She said medical.
Oh, no. Any medical bills, both of the children, both Alan and Alina, are covered on my medical. I think, I'm not sure what Kelly has in regards to any additional insurance, but I have always covered them. So whatever medical.
Okay, she's not talking insurance. She's talking uninsured. So it's whatever your medical is paid that they have not covered. She's saying there's an additional deficiency there that you have not contributed to. Ms. Parrish, have you provided him with I guess, an accounting of what insurance paid and what's not been paid?
I have multiple times. I do have those dates that I have sent him photos of the actual bill with the account number so he can call to Bronson. And they're both through Bronson Battle Creek. They're local providers that are in. I always go to in-network, so it's less expensive.
Okay. Well, are you saying you didn't get those, sir?
No. I'm not saying that. I have received, and the bills that still need to be paid off in regards to both of the children, whatever I can pay, I try to pay. I am in extreme financial distress at this point in time. I am not shirking my responsibilities for Alan or Alina whatsoever, and it's not meant to seem that way. I just don't. I don't think that Ms. Parrish understands the.
Okay, well, let me tell you what
that I'm
happens.
currently in.
Well, I'll tell you what happens. The court enforces its judgments and its orders. And
yes,
all of that is well and good. And we understand it may not be that you're intentionally shirking your responsibility, but the issue is whether you are complying with the orders of the court. And she's saying that you're not. And what we're going to have to do is if there's a dispute as to that, then we're going to have a hearing and make a determination of whether, how much is owed, et cetera, in this matter. And then you'll be required to pay that particular amount.
Okay. I'm not disputing that I do owe. I will be more than willing to
okay. On the medical,
to have Kelly tell me exactly what it is I owe, and I will do my best to make payments on what I owe.
Okay. Ms. Parrish, what is the amount? Do you know what the amount is on the medical that's owed?
I do. He did make a $140 payment a year ago towards that. And so his balance towards the total, I owe 214 and he owed 320. He did pay $40. So right now he currently owes 280 on and for Alina, I just got that bill and provided him with that probably 2 weeks ago, and that's $169. And I don't know the math on that. 60% $169 would be his.
Okay. And the amount of the spousal support that he's delinquent on, how much is owed on that?
Only for 2023, there's still 1 year left of spousal, but for 2023, he owes $496.
Okay. Are you disputing that amount, sir?
No.
Okay. What I'll do, Ms. Parrish, I'll allow you to put in place an order which states that he is in fact delinquent and owes spousal support in the amount of $496 for the year 2023, and that he owes the particular medical, the 280 and whatever the percentages is of the other amount. Let me see.
Okay.
His amount would be of the 169 would be 101.40, so $101.40.
Okay, thank you.
Put that amount in, and then at that particular point, he has those numbers that he ends up having to pay. If he doesn't pay, then you can proceed. At that point, ma'am, you can do a number of things. You can go after and seek a garnishment of his wages. You can seek an attachment of assets or any other seizure of assets, et cetera, which would satisfy that obligation. That's up to you. So, but the court will let you put in place that order, and you can submit it under what they call a 7-day notice of entry. So if you get it in within 7 days of today's date, you don't need to schedule it up for entry. If you don't get it in within 7 days of today's date, then you'll have to send it to him, get it up, noticed of entry, and then we'll have to have a hearing on that.
Okay, do I just type it and mail it directly to him?
You have to mail it to him. You do the original to the court with a notice of entry.
Okay. I again, Your Honor, I want to go on the record as saying I let a lot of this go because of the post majority, but when he entered to have that terminated, I
don't need to know that. That's irrelevant to today's hearing. So I understand, but just get the order entered, and then we'll have the numbers and the amounts that are owed. Okay.
Thank you very much, Your Honor.
Okay. Thank you. We'll conclude at 10:43 a.m. Have a good day. Court will note the appearance of Mr. Vanderhorst on behalf of Mr. Todd. Is that correct, Mr. Vanderhorst?
Yes, just for today, Your Honor.
Okay. This matter is before the court on the plaintiff's motion for reintegration of the child and remove parenting time conditions. Mr. McMaster, you can proceed.
Yes. Good morning, Your Honor. 13 months ago, there was a no contact ordered between, at the time, 5-year-old Jacob and Kelsey, 4 years old at the time. I've personally met with 5 different counselors, CPS investigators. I spoke with the CSC investigator, and I have a report written up from the SANE nurse that performed the SANE examination on Kelsey, which is that gynecological examination. No one has found that Kelsey was in fact sexually assaulted, period, let alone by Jacob. The closest incident that we could come up with to justify this response was an incident where my fiance's 3-year-old and 5-year-old and Christine and I's 4-year-old Kelsey were attempting to spank each other's butts. Several counselors have stated the reunification process should begin as soon as possible for the psychological well-being of the minor children. As a precaution, I've installed cameras throughout my house in order to protect the children from any other accusations or incidences. Both Kelsey and Jacob have been attending counseling. Kelsey has been attending counseling with Sandy Burdick at Battle Creek Counseling. Sandy is in agreement with reintegration as soon as possible. Her recommendation was to have the first meetup to be in a public setting. Christy, the defendant, and I have been participating in co-parent counseling, and we are all in agreement that reunification should begin. I have included in my motion Meredessa's steps for reunification. Christy, the defendant, and I have both agreed to allow Meredessa to supervise and oversee the reunification process, and we are both willing to accept her recommendations. So I respectfully request that Your Honor modifies our current order to remove the conditions for the minor children to be kept separate, for parenting time schedules to revert to the previous alternating weeks as they were prior to the December order, communication solely through our family wizard. And I'm requesting that communication shall be respectful and only about the children. Allow for any decision on reunification of the minor children to be determined by and under the guidance and supervision of Meredessa Katz, our co-parent counselor. And the last request I'm making, my last request is based on sporting events and school activities. More specifically about my son has asked for why I haven't been able to come to some of these events on his Mother's Week. So I'm asking for explicit granted permission to attend school and other activities of the minor children, regardless of which parent's parenting time is currently occurring, and that both parents shall refrain from contact with one another during these activities, but also allowing the children to have contact with either parent during these activities. I feel this is in the best interest of the children. The defendant has stated that she is in agreement with these issues, and that I've presented, and I'm pleading with you that the court can provide us with a written order to allow these issues to please be resolved.
Okay, thank you. Mr. Vanderhorst, what's your response?
Your Honor, this whole case really revolves around the plaintiff's current girlfriend and her 3 children. The parties do share 2 children together. The 2 children, Colton and Kelsey, 7 and 5, they're sharing joint custody, joint physical custody with them. The whole problem has been the girlfriend and the 3 other children. This case has a lot of history. Obviously, the court's well aware of that. I think it's premature now to start changing all kinds of things. I think they've made progress. There's 2 or 3, maybe 4 different counselors involved with these children, Your Honor, at the present time. I believe all of the counselors should talk to one another if they haven't. I know Dr. Meredessa Katz is the main point person, so to speak, on this case that is working towards a reunification and does have some thoughts and some recommendations on that. But quite frankly, my client and I haven't had a chance to go through them at this time. This isn't my case, so I would say that we work towards those goals, Your Honor, but we're not there yet. And I think there's some things about supervised parenting time when the girlfriend and her kids do spend time over there with the other 2 children between the parties. There's still a lot of loose ends, Your Honor, that need to be fleshed out. I think we can get there, but we're not there yet. So
Okay.
Maybe we schedule it for an evidentiary hearing down the road if we need it, just as a safe net, Your Honor.
Okay. Do you have any problem with, again, providing that, the plaintiff would be able to attend school activities?
I don't think that'd be a problem, Your Honor.
Okay. Okay, with that not being a problem, the court will order that. And the court will also order that the therapy as suggested by Meredessa Katz would continue in this particular matter. The court would, do you have a problem with the recommendations of Mrs. Katz as contained in paragraph 12?
Let me just check that, Your Honor. The problem with that, Your Honor, is who would the supervisor be? I need some time, or Mr. Todd is going to need some time with our client to flesh what that means. And I think we might be able to get there, but right now, Your Honor, it's premature.
May I speak?
Yep, go ahead, sir.
In that paragraph, it clearly defines the third party as Meredessa Katz to supervise the process.
Okay. You have a problem with Ms. Katz supervising?
Can I ask my client, Your Honor?
Yeah, go ahead.
Christy, what do you think?
I think it would be hard to get her available as often as we would need it to get this going faster. I think she's really busy. So, I mean, I'm okay with it. I just I feel like some of it, us being pushed back, is because we've waited so long for her to kind of step in and take over because she said she wanted to. So I don't know if we should rely on her to be the supervisor to get things
Well, we could.
I'm okay with it. I just don't know if she will be available to do
What we
this.
could do is state that it would be, again, that Ms. Katz would be the one to supervise or any other third party as the parties may agree. So that way it gives you the option for the two of you to agree to some other third party. So.
And
why
I'm
don't we-
sorry, Your Honor, can I just say one thing? I'm so sorry. I did offer for him just to let me know what events he wanted to go to. I don't feel comfortable just going to events and having him be there without me knowing. I would
Well-
rather just not go.
Well, okay, I understand, but unfortunately, when you have parents and kids have events, parents can go to those events. It's a public situation or a public forum. And so the court.
Can he just let me know he's going so that I don't?
I'm not going to require they to let you know. I just, if he's there and you wish to leave, you can always do that. He has a right to go to any public activities or things of that particular nature. So what I'll do is I will order again, that the parties would again follow the recommendation of Ms. Katz as contained in paragraph 12 of the motion, and that she would supervise unless the parties can, come to an agreement as another party. Mr. McMaster, you have to understand, if you can't come to an agreement, you're going to be stuck with her schedule, which is very difficult to get into. So I guess that's your choice. And
Yes, but sorry.
And that the therapy would continue, et cetera. Okay? What
Very
else?
good, Your Honor.
Anything else, sir? Mr. McMaster?
Oh, I was just saying that Meredith Katz has explicitly stated that she has interest in overseeing this and
That's
seeing it
fine.
through.
I'm just saying that if the two of you can agree to someone else, that's fine too. So it's up to you. And so what happens, sir, you're going to have to prepare an order from this hearing because you're the moving party. And you'll have to submit that to Mr. Todd for his approval or submit it under a 7-day notice of entry. Okay?
Okay, sounds good.
Okay. Thank you. That will
Okay.
conclude this
Thank you,
matter
Your
at
Honor.
10:54.
Thank you.
Ms. Ray Magnuson as well on behalf
Thanks,
of the
Chris.
front of the court. The defendant filed a motion to determine child born out of wedlock. I'll ask you, Mr. Verlerman, have you done a DNA test in this matter?
I have not. I didn't know if it was necessary because we both agree that it's not my child.
Okay, well, you can agree. It's just a matter of, is there a possibility that it's your child? If, for instance, you came in and said, look, we were separated for 3 years prior to the child's birth, then obviously there's not a possibility, and we wouldn't need.
I'm sorry.
So what are the facts in this matter? Obviously, the child was born in January of 2023. So I'm not going to take testimony at this time. I just need to know in fact, probably what we'll need to do is just schedule for an evidentiary hearing. We do these on Wednesdays at 1:30, so we can take some testimony. If in fact there's a possibility that it could be your child, then you're going to need to do DNA testing. Mr. Magnuson, what's your position on the DNA testing?
Well, I think the court's spot on this. I would indicate that based on the circumstances of this case, if the court is to order genetic testing, this is a 4D case, and our office would be able to facilitate the genetic testing at a much reduced cost to the parties based on those factors. So I just want to put that out there. I'm fine going that route if the parties, if that's acceptable to them, or setting it straight for an evidentiary hearing.
Okay. Ms. Farman, what's your position in this matter? Tiffany.
Sorry.
Go ahead.
Our separation date is about October of 2017.
Oh, so a real long time before the child.
Yes.
Okay.
Yes. So I just wanted to state that.
Okay. Well, I think we can probably go ahead with an evidentiary hearing, take some testimony. It's pretty brief. It might take us like 15 minutes. We do those on Wednesday though, because like today we had 22 hearings and we still have more hearings. So we don't have time for testimony today. So what we'll do is we'll contact the both of you and schedule it for that hearing. If I know the alleged father, Mr. Lasher, if I guess I'll ask you, Ms. Brarman, would you be able to have him present at the hearing as well?
Yes.
Okay. If you would, we'd appreciate that. Then we can make a determination at that particular time. But we'll be in contact with you and set up a Wednesday afternoon at 1:30 when you're available to take testimony.
Okay.
Okay. Okay, thank you. We'll end this matter at 10:59 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Magnuson on behalf of the court. This matter is before the court on the defendant's objection to the order. Sir, you're muted. You have to hit the mic on the lower left corner to unmute.
Okay.
You file an objection to the order, stated that your objection states that you did not agree to that particular ruling. I'll just let you know, you don't have to agree to the ruling. It is a ruling as opposed to an agreement, so you don't have to agree to that. What's your basis for your objection?
That me nor her, I'm doing half custody, so the order wouldn't be right anyway. And neither me and her already agreed to I get half custody, and I'm taking him week on, week off. So the ruling that was given doesn't add up to that, and it doesn't calculate right when it comes down to support on that matter, you know. So whether I agree to it or just rule that, it's still got to be reversed in some type of way, because I'm taking care of him in my household too half of the time. And it was never a DNA given for the order, which I understand was a default on that case. But we did ask when we had the first hearing to get a DNA test, and they said we had to file an objection to that. So that's where I'm at with it. That's why I objected.
Okay. Ms. Crapo, what's your response?
Mine's pretty much the same thing. We've been doing week on, week off for about 4 or 5 months now. And our last court hearing, they told us that we had to come down and file paperwork, which I am at front of court right now as we speak, still filling out paperwork, because he does his half and I do my half. And we both support our son on our own weeks. We don't give on each other's weeks. So.
Okay, Mr. Magnuson, maybe a little bit different situation than you're faced normally. What's your position?
Well, thank you, Your Honor. First, just to clarify procedurally on this for the record, we did file this case back in June. A default was entered. We pled certain amounts of income in the complaint and certain other factors. There was no response, and a default did enter. The parties did show up at the hearing on October 27th, and the order was entered based on the default situation. Going forward, if my thought is to treat this as a motion by the parties to modify that order, I believe it should remain in place based on the procedural history. But if the court wants to set it for an evidentiary
Hold 1 second. Sir, in this matter, this is a court proceeding. Don't smoke during the proceeding.
Okay, gotcha.
Go ahead.
Sorry.
The court may set this for a further evidentiary hearing with the referee to take into account these new circumstances. I have no problem with that. My main focus is that I believe procedurally the order that we obtained should stand as it was obtained in a procedurally correct manner.
Okay. Well, it does appear, Ms. Crapo, you're down there filing something, so go ahead, continue to file your, I guess you say your motion to modify.
Yeah, because our biggest thing was he's putting him on his actual insurance through his job. I guess their biggest issue was that my son was getting Medicaid. So that's no longer going to be an issue at all. So
well, file the motion so that we have something for the referee, and state in there that the two of you had agreed to joint custody, and that he was in fact doing that. And as a result, there would be a factual basis for doing that. But at this point, there's not. Obviously, the referee didn't commit any factual or legal error at that time. So the court's going to allow that order to stand until such time as we modify it. And what we'll do is I'll just simply send the matter back to the referee for a hearing on custody, parenting time, and support.
And that's supposed to be for tomorrow, correct? Because we have another court date tomorrow for the parent in custody.
Okay, I wasn't aware of that, but you can let the referee know that you had a hearing today and that sent it back to them to address the custody, parenting time, and support.
Okay.
And he should have an order in the file, but he may not have the order by that time because we'll get it entered today. But so we'll just refer it back to him. He can take care of it at that time. Anything else, sir?
No, as far as the DNA test, how does that work now? Can we still get that, or is that something we have to go just do on our own now?
Well, you can do it on your own. But if you're going to want the court to order that, you're going to have to file a motion so that the court has a basis to do it. I just can't do it because you've asked for it. You got to file a motion. That way, Mr. Magnus have a chance to respond, et cetera, as well.
Okay, well, it's fine. No, yes, we'll do it in the future. All right.
I will let you know. I don't know how old the child is, but in fact, you have a 3-year statute of limitations window. So you're gonna, if you're up against that 3 years.
Yeah, he just turned 2.
2, then you need to get a file before the child's 3, or otherwise you could end up being paying until the child's 18.
Okay.
All right.
Okay, so you file the motion, ma'am, and then we'll have the referee address that tomorrow, or he may want to adjourn the hearing tomorrow to give him more time to address everything at that hearing. Okay?
All right. Thank you so much.
Mr. Magnuson, anything else?
No, thank you, Your Honor.
Okay, thank you.
All right.
We'll end this matter at 11:07. Both of you. The court will note that this matter is before the court on the defendant's motion to dismiss in this matter. Apparently, Ms. Moore, you are claiming that venue in Calhoun County is not proper. I would note you do cite to Michigan Compiled Laws 722.26 parens 2. I will tell you that pertains to third-party custody cases. It doesn't provide and pertain to instances where it is the parents that are addressing the issue of custody. So anything else that you have, ma'am, as it relates to this particular matter?
Yes, Summer had lived at the 9/5/22 days with me at the time that the complaint was filed, that's in Washtenaw County. The plaintiff denies in his answer that was Summer's home. However, he stated in the complaint and the sworn UCCGJEA affidavit that her residence was not, which is in Washtenaw County.
Okay. So that's the basis, is that there was 20 days in Washtenaw County as compared to Calhoun County?
22, yes.
Okay. Anything else you have to add, sir?
Your Honor, good morning.
Good morning.
I'm requesting an adjournment of today's motion. I received defendant's motion this past Tuesday afternoon, November 21st. I placed a call to Attorney Scott Jensen, J&C Law, requesting to set up a time to meet. With a short week due to the holiday, I'm anticipating a call back today or early this week. I assembled and served defendant and defendant's attorney a written response this past Friday, November 24th, and also filed a copy along with proof of service to court this morning.
Okay. Well, that's fine. You don't need to go on. What I'll do is, in these instances where you want to seek the advice of an attorney, the court will grant you that opportunity. So what we'll do is we will adjourn this matter for 2 weeks, and I'll ask Ms. Moore that she would renotice the matter for that 2 weeks.
Okay. Your Honor, may I ask about the proposed orders setting aside the default that I sent under the 7-day rule?
The issue before the court is a motion to dismiss. That's what we're addressing today. Okay, I'm not going to take up any other matters that are not properly noticed for today's date. So that will be the order. We'll adjourn the matter for 2 weeks and then take it up at that time. You're free to go. We'll end this hearing at 11:11 a.m. Have a good day.
Thank you, Your Honor. You have a good day as well.
Good morning, Ms. Marshall. The court will note that this matter is before the court on the plaintiff's notice for entry of an order for genetic testing. It's my understanding, Ms. Marshall, you wish to have genetic testing of both Mr. Watson and Mr. Scott. Is that correct?
Correct.
Okay. Well, the court will note that neither of those parties have responded nor appear today. It is now 11:12 a.m. The matter was set for 10:30 a.m. The court will grant your motions in this matter. So what will happen is you'll have to submit an order for genetic testing on both of the defendants in this particular matter.
Judge, she submitted orders.
Oh, you have submitted those?
Yes, it's a notice of entry of orders.
Okay, then we'll just get those entered then. That's fine. You don't have to submit other orders. I didn't know that they were there. And we'll get those entered, and then as soon as the testing is done, then you can contact the court and we will schedule hearings at that time, okay?
You said when the testing is done,
Excuse me,
contact the
ma'am?
court. You said when the testing is done, contact the court to.
Yes, because what happens, we're gonna want that, the test results prior to the evidentiary hearing.
Okay, so, and what if I have an issue getting them to take the genetic testing?
Well, you can always file a motion to show cause to, why they shouldn't be in contempt. What happens technically, well, we're gonna need both because you want to establish paternity, so we're going to need testing on both to exclude one of them. So, we'll get the orders done, you'll get them served with the orders, and then, what we'll do is we'll probably have them that they do the testing within 30 days of the date of the order. And then we'll be able to proceed, okay?
Okay, and then is there a way that I can get testing done? Because Aviana has a sister by me, which her name is Alea, and Demetrius being the dad that we know is the dad. Is there a way I can get the two sisters tested or no?
Not unless you file proceedings pertaining to them. Or unless the Mr. Watson or Mr. Watson would be the case, unless he agrees, you can get him tested as relates to those two as well.
Yeah, because he's already listed as Alea's dad.
That's fine. I'm just saying, if you want the testing done and he agrees to that particular testing, then you can get it done, or otherwise you're gonna have to file a complaint.
Okay.
Okay?
And can you tell me one more time, what's the motion that I would have to file to like get them to force them to take it?
Well, the same as you file with regard to the other two fathers, as to him and Mr. Scott, because you've only identified the one child in this action.
Well, I don't need testing for Alea because he's already been identified as the dad for Alea. I was saying more as, could I get Alea tested and Aviana tested to show that they have the same dads? But
well, you're saying she's already determined to be, that Mr. Watson's already determined to be the father, correct?
Of Alea.
Yeah, so you don't have to have her tested if that's what you want to determine. If you want to exclude him.
No, I was saying more of, if I couldn't get Demetrius to test, couldn't it come back showing, because Alea and Aviana have both the same mom and dad, will the test still come back the same?
Not if we don't have testing.
Okay.
You know, you could file and seek and get a default against him. I guess you could do it that way. And then he would be determined to be the father. That would be the way to do that if he doesn't cooperate. So it's to his benefit to cooperate if he wants the other child excluded.
Yeah, we're trying to exclude Aviana from Jalen Scott.
Okay, well, that's fine as well. You can proceed with that, or if in fact, yeah, that's fine.
Okay, I'll get a motion started because I've been trying to get Demetrius to go take a test for the past couple of years now, and I think he's more avoiding it because we're not together, and he just doesn't want to be charged child support.
Yeah. Well, what you could always do too is check with the front of the court and see about maybe they would assist you, because we have Mr. Magnuson at the front of the court that handles these matters, and that might are you getting public assistance at all?
Yeah, I get food stamps.
Okay. Check with Mr. Magnuson at the front of the court, and he may file the action on your behalf, the complaint for affiliation determining paternity. So
okay,
that's the way I suggested. He knows what he's doing, and it would be much easier than you trying to discern and decipher what you have to do. Okay.
Right. Thank you.
Okay. We'll conclude this matter at 11:18 a.m. Have a good day.
Attorney Michaela Bendaly for plaintiff. Here we go.
Okay, good afternoon. How are you?
Hello, Judge Mull, and yourself?
Doing well. Let me ask you on this case, what are the issues in dispute in the Cole Brown versus Mays?
I'm hopeful. I haven't spoken to Mr. Mr. Mays about this, but I'm hopeful we'll be able to finalize an interim order. It's my understanding right now, the parties don't necessarily have an agreement as to joint physical custody. As I indicated, I'm hopeful we could get something to an agreement, but we would just ask that the court would set a trial date for an evidentiary hearing on this, so that we have a deadline by which to go, or send it to mediation. I don't recall the court's preference at this time, so my
Okay,
apologies.
well, what we do is we always send them to mediation first. Are you in need of discovery in this matter?
We would request discovery. I'm not sure the extent to which we'd use it. I would also supplement, 'cause I see that Mr. Mays came on. I think the parties had some issue with the Thanksgiving holiday. And I looked at the order and we had used the guidelines on the Calhoun County front of the court's website. I see there's some parentheses that may have caused confusion based on those recommendations. And as part of this order, would the court permit leave to submit an order 7-day to correct the inclusion of parentheses on the holiday schedule, since we have Christmas coming up?
Well, I will if you have a stipulation to that. Otherwise, you'll have to file a motion.
I can contact Mr. Mays on that.
I don't see, is Mr. Mays on?
I think he's on now, Judge.
Okay. Mr. Mays, are you on?
Yeah, I'm here.
Okay, sir, what issues do you believe to be in dispute in this case?
Actually, I was hoping to get maybe an adjournment. I just received the paperwork in the mail this past Saturday, and I was hoping to have more time to go over it and respond as far as get legal representation.
Okay. We can do that. What we'll do is we won't adjourn it out too long. We'll probably adjourn it out a couple weeks. So you'll have a couple weeks to get representation. And then at that point, you'll need to have them present. Okay.
Okay.
Judge, I would just supplement. I think the document to which he's referring is the interim order that we sent out that the court entered.
Okay. Regardless of what it is, he wants representation. So I'm gonna allow him to get that. So, okay, what we'll do is adjourn this out a couple weeks and we'll send you a new notice and then see you back at that time. And Mr. Mays, you should be able to have your attorney present at that time.
Okay.
Okay.
Thank you, Judge.
Thank you. We'll end this matter at 1:21
p.m. Attorney Daniel Busher for plaintiff and Attorney Fisk for all 4 defendants.
Okay. Good afternoon to all of you.
Good afternoon, Your Honor.
This is a time and place set for a status conference. I'll go to you, Mr. Busher, first. Tell me what's happening from your standpoint at this point.
Right. At this point, Your Honor, we're in the very, very early stages of this matter. I know Ms. Fisk was just retained. Defendants were just served. We have a motion for preliminary injunction scheduled for Monday. And at this point, we haven't really talked about much else or the merits.
Okay. Ms. Fisk, is that your understanding as well?
Yes, Your Honor.
Okay. Well, at least now we have service, so that's progress, I guess. And what we'll do is, I guess, at this point, we'll just address the motion on Monday, next Monday. If that's, I don't know if that's when it's scheduled or the following Monday, but whatever it is, we'll address it at that point. Is there anything else you need to address today, Ms. Fisk?
No, Your Honor.
Okay. Well, we will go ahead with that, and then that'll help us progress in this particular case. And then you've got the case scheduling order, so comply with the case scheduling order at this point, and then that will move us along. And you should be thinking about who you want to mediate the case and get us a name of a mediator, because if you don't, then it'll get set to the mediation clerk and they'll just randomly assign someone. So try to come to an agreement as to who you'd like to mediate the case, and then that'll help us move forward as well.
Very good. Thank you very much, Your Honor.
Okay, we'll let you go now at 1:26 p.m.
At 1:29 p.m.
Have a good afternoon.
Attorney capture for defendants.
Okay. Good afternoon to both of you. Ms. Doherty, this is a scheduling conference, and it's whereby we put in place various dates and processes to allow the case to proceed in an orderly fashion. And what I'm going to do is go to you first and then to Ms. Capture. So you can enlighten me, what do you believe to be the issues in dispute in your case?
We are trying to come to an agreement on the division of property, which is essentially the home we own, and custody of our son.
Okay. Ms. Capture, that your understanding of the disputes at this point is all child-related matters and property?
Yes, Your Honor.
Okay. And are you in need of discovery?
No,
No?
we've exchanged this, so that's going well.
Okay. Ms. Doherty, discovery is the process whereby you can acquire information from the other side through any of the discovery tools, which would be interrogatories, requests for production of documents, depositions, or any other means that you have available to you by serving subpoenas, et cetera. Do you anticipate that you're going to need any discovery?
No, Your Honor.
Okay. I will put down none as it relates to discovery. Ms. Capture, what do you think you would have be ready for mediation in this matter?
I think this case might get settled without mediation, but I think if we set it January,
okay,
I think that we'll have an order to you soon.
We're obviously new in this, or early in this matter, so why don't I just set mediation to occur in February? That gives you a little more time to try to come to a resolution in this case. Who would you like as a mediator, Ms. Capture, if we end up having?
Brundage, please.
Okay. Ms. Doherty, do you have any problem with Mr. Brundage serving as a mediator?
No, Your Honor.
And if he's not able to, who would you like as an alternate?
Let's do Lisa.
Okay. Do you have any problem with Lisa McNiff serving as an alternate should Mr. Brundage not be able to handle the matter?
No.
Okay. Well, again, I put the date off that way. If hopefully we would be able to come to some resolution prior to that time. I will set March 4th as the settlement conference date. It's at 1:30 p.m. All parties are required to be present unless we've come to a full resolution prior to that time. Again, if you do come to a resolution prior to that time, then we won't need the settlement conference, but we have it in the event that we come to a roadblock and we can't get any resolution of all of the issues. Anything else, Ms. Doherty? Do you have any questions or anything before we conclude?
No, I do not, Your Honor.
Okay. Ms. Capture?
No, nothing further, Your Honor.
Okay. Ms. Doherty, you're going to get a case scheduling order which will recite all of the things we've been talking about. I will tell you to pay attention to that order because there are dates in there of things that you must do if in fact the case doesn't resolve and you have to go to trial, and some of that could be again damaging to your case if you don't comply as far as witness lists, exhibit disclosure, etc. So just when you get that, just make sure you read it, pay attention to it so that those dates are not missed. And you'll get that in probably about a week at the latest.
Okay, thank you.
Okay, thank you both, and we'll conclude at 1:34 p.m. You're free to go. Have a good day.
Thank you, Judge.